Good morning and welcome to the 24th meeting of 2025 in Session 6 of the Equalities, Human Rights and Civil Justice Committee. We have apologies this morning from Tess White. Our first agenda item is to decide whether to take item 4, which is consideration of evidence heard on the draft affirmative instruments in private. Are we all agreed? Agreed. Thank you. We're all agreed. Our second agenda item is consideration of the following 2 draft affirmative instruments: the Regulation of Care, Child Contact Services Scotland Order 2025 and the Regulation of Care, Child Contact Services Equalities Scotland Regulations 2025. I therefore welcome to the meeting Siobhan Brown, Minister for Victims and Community Safety, and the Minister is accompanied this morning by Wendy Jorgensen, Family Law Team Leader, and Scott Matheson, Senior Principal Legal Officer from the Scottish Government Legal Directorate. Thank you for joining us this morning. I refer members to papers 1 and 2 and invite the Minister to speak to the draft instruments.
Thank you. Good morning, Convener, and good morning, Committee. These 2 draft instruments relate to the regulation of child contact services in Scotland. As the committee are aware, this is something the Scottish Government has been working towards for some time. Our overall policy aim is to ensure that child contact services are safe, conflict-free, child-friendly places for a child to spend time with a parent with whom they don't live with. And there is widespread support for such regulation. Child contact services have an important role in the family justice system, helping children to maintain relationships when parents separate and doing this in a supportive and a child-focused way. There are currently around 45 child contact centres in Scotland, and there is already good practice happening in the sector, which I have seen firsthand. However, there is currently no external regulation of child contact services. And a key driver for regulation is to have a body in place providing independent oversight. And having that oversight will ensure there is good practice consistently across the sector, whilst also driving improvements where needed. The first instrument, the draft order, will extend the Care Inspectorate's regulatory framework to child contact services by adding them to the list of care services that they regulate under the Public Services Reform Scotland Act 2010. This instrument effectively puts the Care Inspectorate in place as an independent oversight body. The Care Inspectorate has been our preferred choice for this role for some time. They are an experienced scrutiny and assurance body already regulating a range of service used by children and families. We believe the Care Inspectorates are best placed to provide oversight and to help achieve the best outcomes for children using child contact services. We've been in detailed discussions with the Care Inspectorate during our preparation of these SSIs. The second instrument is the draft regulations will confer an additional function on the Care Inspectorate, requiring them to notify the Equalities and Human Rights Commission of any failure of a child contact service to comply with their duties under the Equality Act, in particular the duty to make responsible adjustments for disabled people. The Equality and Human Rights Commission are the appropriate enforcement body for these existing duties, and the purpose of this function is to help ensure child contact services are meeting their Equality Act duties without placing any additional duties on them. Both draft instruments provide for a lead-in period of 18 months before regulation will fully come into force on the 1st of April 2027. This is to ensure that the Care Inspector will have sufficient time to carry out the necessary preparatory work, and child contact centres are going to be a new type of sector for the Care Inspectorate to regulate. So they're going to need time to build knowledge and understanding of the sector, as well as to recruit and to train new staff, prepare materials, for example, in relation to registration and also to complaints, and to develop a bespoke quality improvement framework. There will be engagement with the sector and other stakeholders during this time. So the 18-month period will also give child contact services time to familiarise themselves with the new regime and also to prepare. In conclusion, Convener, these 2 instruments are a significant step forward towards the next phase of implementation for this regulation work, and the next 18 months will be important in how the Care Inspectorate regulatory framework will be shaped for child contact services. And I'm happy to take any questions, Convener.
Okay, thank you, Minister. We'll now move on to questions. And Pam Gossel, please.
Thank you, Convener, and good morning, Minister and officials. And thank you, Minister, for your opening statement. Minister, as you already know, children experiencing domestic abuse are already extremely vulnerable. That is why we must ensure they are kept safe in child contact centres. The regulations put forward by Government would require the Care Inspectorate to report a failure of a child contact services provider to comply with the Equality Act 2010. Minister, are you confident that the proposed regulations address concerns for families affected by domestic abuse in relation to child contact centres?
Yes, I thank the member for the question. One of our key policy aims here is to ensure that child contact services are safe and conflict-free venues for contact to take place, which we all know is extremely important for the children. And as we've heard concerns from the Scottish Women's Aid about the need to ensure the safety and well-being of women and children in child contact centres. So we expect the new regime to take account of the need for child contact services to understand the dynamics of domestic abuse, and the Quality Improvement Framework will support this. New staff recruited by the Care Inspectorate to take up roles in this new area will be upskilled in delivering in the child contact services environment and have an understanding of domestic abuse and its impacts. And we understand that the Care Inspectorate already regulates other services where domestic abuse can be a factor. So there is knowledge to draw from here. And to give the members some comfort, I know Scottish Women's Aid have provided useful recommendations in previous consultations and engagements in this area. And we will be sharing this with the Care Inspectorate during the lead-in period. And the Care Inspectorate will also have to consult with key stakeholders when developing their quality improvement framework. So I hope that gives the members some comfort.
Just got a little add-on question there. You talk about that you've obviously had consultations and work done with Scottish Women's Aid. Could I ask the Minister if the Minister has done any work with other organisations?
Yes, so when we've been drafting these SSIs, there's been a series of stakeholders that we have engaged with. If I may just maybe ask one of my officials to answer that question, if I can.
Yes, apologies. Yes, we consulted publicly in 2018 as part of a wider family law consultation, and that we sought views then on the whether to regulate child contact services, and then we had a further consultation in 2021 around some more specific proposals under the Children Scotland Act 2020 provisions, and Scottish Women's Aid were kind of key in that, and also there was a range of other organisations that responded to those consultations. More recently, we sent sort of targeted consultation letters to a range of our kind of key stakeholders in this area. I think we've provided a list in the impact assessments, but if you'd like me to kind of run through those, I could, but that'd be something the committee would like to hear.
No, thank you for that, Minister, and thank you, Wendy. It's more to, if I can be more specific, to say that even if you write to the committee and let us know, it's good that obviously Scottish Women's Aid, you've got information from there and other stakeholders. I think what I'm particularly interested in is the BAME communities, because obviously it's very different culturally, how basically a domestic abuse case is, and especially with child contact and things like that in centres, what kind of role they play. And one size, I always say, never fits all. So it's just to understand, if you went out to people like Sikh Sanjog, AMNA, these kind of organisations, and kind of seen the other side of, to see how BAME communities have talked about, and BAME organisations that deal with domestic abuse from those cultures every day.
I don't think we sent any of the kind of targeted letters on proposals more recently to those organisations, but we have now, or we will have a sort of lengthy kind of lead-in time. So I think we would be quite happy to follow up on that and can let the committee know about our engagement with those organisations. So yeah, we're happy to take that forward.
No, thank you very much for that. Yeah.
Okay, thank you. Minister, when what became the 2020 Act was going through Parliament, one concern expressed was that without sufficient funding for providers, new regulatory requirements would be too onerous for some providers. And this could lead to centres closing and parents potentially having to travel long distances to see their children, particularly those who live in rural areas. How confident are you, Minister, that this policy risk will be avoided in practice?
Yes, thank you, Convener. I think one of the things just to highlight that I said in my opening speech is there will be costs involved for the Care Inspectorate in taking on the role for additional staff, for example, inspectors, complaints advisors, etc. And the Scottish Government do have a strategy of funding over the next couple of years, just in relation to your concern that child contact providers might not meet the registration requirements and there might be closures. We want to try and avoid any reduction in the number of child contact services, since any lack of availability obviously will impact negatively on children who use the services and the wider family justice system. So the intention is that regulation should not be onerous, and that the 18-month lead-in time before regulation fully comes into force will help providers in terms of planning and preparing for it coming into force. And we will work with child contact service sector and the Care Inspectorate through the lead-in period to support existing services as they prepare for regulation coming into force to make sure that they're ready when it does on April the 1st,
Okay.
2027.
Thank you. We'll now move on to questions from Maggie Chapman, please.
Thanks very much, Karen, and good morning, Minister. Good morning, officials. Thank you for being here this morning. Minister, you mentioned in your opening statement that the Care Inspector would report to the Equalities Human Rights Commission any issues around the Equality Act, specifically around special adjustments. Given that service providers are already required to meet those standards and those duties, why did you consider it important to include this in these regulations?
Yes. So the issue of disabled access to child contact centres was raised during the passage of the Children's Scotland Bill, which is now the Children's Scotland Bill 2020. I think this was previous to our time here, but this led to the bill being amended to provide that the body appointed oversee regulation that would have a function of reporting any failures under the Equality Act's duties. And the intention was to help ensure compliance of these existing duties. So we are now proposing that, as said in my opening speech, that the Care Inspectorate takes on this role. The EHRC are the appropriate body to enforce the equality duties, not the Care Inspectorate. So the instrument would just make it clear for them to notify that body to take further action.
So it's the notification that's the key thing here.
Yes.
Because the duty to comply already.
Yes, it would not be up to the Care Inspectorate.
Okay.
Yeah.
And are you aware of any other examples of legislation where a similar requirement has been made on a regulator, on a public authority, to notify the EHRC in this way?
I might have to. I'm personally not aware, but my officials who've been dealing with this might be aware of one.
We can...
No, I'm not aware of any provision in statute, but we do understand that the Care Inspectorate already would do a sort of similar administrative function for other issues they might come across. So I think they might sometimes sort of contact the sort of Mental Health and Welfare Commission or the Fire Service, the Health and Safety, if there's sort of issues like that. So this is, I say, the requirement to notify is obviously a provision that kind of came historically from the Children of Scotland Act 2020 provisions. But the notification process itself would be a sort of administrative one between the Care Inspectorate and the Equalities and Human Rights Commission.
And I suppose that the 18 months lead-in time gives the Care Inspectorate and the EHRC time to work out exactly what that procedure would look like, how and what responses would be normal, if that's the right word to use.
That's right. The Care Inspectorate will, I think the regulations sort of provide for the Care Inspectorate to sort of come up with a format for that notification, and we'll agree that with the Equalities and Human Rights Commission. And then once the notification is made, it'll be for the Equalities and Human Rights Commission to obviously decide which action to take if action is appropriate.
Okay, thank you. That's helpful. Thanks.
Okay, thank you. We now have questions from Rhoda Grant, please.
So given that there are no examples of this happening in legislation previously, Do you think that there's a possibility that that approach could become more common in future in different areas? And what impact would that have?
I think it possibly could, but I think at the moment where we are referring it's just really to ensure that they are compliant. It's not, as I say, up to the Care Inspectorate to rectify, and it's just to refer. One of the things also is that we've had if it's going to put any additional burdens on the child contact providers, so all the service providers will make reasonable adjustments under the Equality Act, and they should already be in place. But I think what we're looking is and how we can refer it and really how we can underline it. But I don't think I could speculate on how moving forward with other legislation that might move forward. I don't know if any of my officials have any other intelligence.
I could maybe.
Okay, Scott.
As Wendy said, the duty to notify the Equalities and Human Rights Commission is being put in the regulations to mirror provision that was in the Children's Scotland Act 2020. If we had gone down the road of taking forward regulations under the provisions in the 2020 Act, the Scottish Parliament, through that Act, has said that provision should be made for that notification, for the Care Inspectorate to communicate concerns to the Equalities and Human Rights Commission. Because we're taking forward the order and regulations here under different enabling powers, because that fits with the statutory scheme which the Care Inspectorate is established under and which regulates other care services under. That provision wouldn't automatically come across, so it's perhaps unusual in the sense that we're providing for a notification which could already happen in practice, but it's respecting what the Scottish Parliament required under the 2020 Act. We're just taking that forward through a different legislative vehicle.
Okay.
Okay, thank you. We now have a question from Marie McNair, please.
Thank you, Convener, and good morning, Minister and officials. Could you say any more about the Care Inspectorate and the Equality and Human Rights Commission's position on the new regulation? Obviously, you've touched on it already a bit, but anything else you want to maybe add on their position?
Not that I've got anything further to add than I've already said about it. I don't know if any officials got anything further. Is there anything specific?
No, that's
No.
fine.
Yeah, we as the Minister said, we've been engaging closely with the Care Inspectorate during this whole process, and we did have some detailed discussions around the provision of this notification function. As Scott mentioned, the original provision in the Children's Scotland Act 2020 talked about a sort of the oversight body reporting any failures, but the Care Inspectorate had some concerns around that because in the context of the work they do, a report has a very kind of different meaning in context of inspections. So that's why we've made provision in the regulations here for a notification function, just to make clear that that they are obviously not the enforcement body for the Equality Act function. So yeah, but I think we got to that kind of agreement with them, a position that they were kind of comfortable with, and we did engage with the Equalities and Human Rights Commission at that time as well. So we will be kind of following up with them during the lead-in period on this. But yeah, they obviously are the enforcement body for these existing duties already, so they didn't raise any kind of concerns at that time.
I'm assured to hear that engagement will be ongoing. Thank you.
Yeah.
Cheers.
Okay, thank you. We now have a question from Paul McLennan, please.
Yeah, thank you, Convener. Morning, Minister. Given that equal opportunities are reserved under Schedule 5 of the Scotland Act, have you engaged with the UK Government on this, and if so, what's their position on regulation?
My understanding is we've not engaged on with the UK Government on this. Unless officials could correct me. Was there a duty that we needed to?
We have had at official level engagement with our colleagues in the Ministry of Justice who lead on child contact centre policy the south of the border. So they have a slightly different situation down there. They don't have a sort of statutory regulators, so they have the National Association of Child Contact Centres, who are a sort of membership, sort of accreditation body. So we have had some discussions just around the proposals that we are taking forward in terms of putting a sort of statutory regulator in place. So there has been some engagement at official level.
No issues raised by them at all?
No, I think they were just more interested to hear about the direction we were planning to go, as I say, because they don't have a sort of similar equivalent in England and Wales at the moment.
Okay. Thanks, Convener.
Thank you. Do members wish to ask any other questions? No? Okay, we will now move on to agenda item 3, which is consideration of the motions for approval for the affirmative instruments. I therefore invite the Minister to move the motions S6M 19400 that the Equalities, Human Rights and Civil Justice Committee recommends that the draft regulation of care Child Contact Services Scotland Order 2025 be approved, and S6M 19401 that the Equalities, Human Rights and Civil Justice Committee recommends that the draft regulation of care Child Contact Services Equality Scotland Regulations 2025 be approved.
Move, Convener.
Thank you. Do members wish to make any final comments? No. If not, are we all agreed? Thank you. That is agreed. Next, I invite members to agree to delegate to me the approval of the publication of a short factual report on our deliberations on the affirmative instruments that we have considered today. Are we all agreed? Thank you. We're all agreed. And that completes our consideration of the 2 affirmative instruments. I thank the Minister and her officials once again for attending this morning. We will now move into private to discuss the remaining items on our agenda. Thank you.